Everybody, it's 11 a.m. every other week Ask a Lawyer live show. Excited to be here. Sorry about the coffee sip there. And so today I'm doing the show out of my office. I've done them in different places over the years or over the times, and so really appreciate everybody coming in, watching. And you can see in my office where we love having this office. We have it in downtown St. Louis. There's the river, the Mississippi River. I can take you around and give you a tour. The reason why I could give you a tour was that we have we built out a new part of our office today. And we moved in yesterday. Our office is always expanding. There's the Eads Bridge over my shoulder and the Mississippi River. And then I'll give you a little tour of the office. This is my office. You can see behind me. And then if you come around, this is my assistant Casey's office back there. And then this is our new offices we built over. This is our new entryway. Boom. We'll get some art and stuff we're putting up. This is one of our new hallways. Going down, the new offices we built out. This is, people are like looking at me going, what's this weird guy walking around? There's Tyler working away. Hey man. Hello. There's the Mississippi River again. Yesterday was moving day. I didn't do anything. My great paralegal assistant Casey did all this stuff. We had a bunch of stuff, a bunch of people helping me. It went very easy. We do most of our litigation work and most of our legal work out of here. Because of COVID, we are still doing a hybrid work from home, as well as and this is our conference room, one of our conference rooms, with all of the stuff, everything hung up. That's our old conference room. And we still do most of our litigation support. We have people at home. This with the Delta variant, we're still having to accommodate and adjust for illnesses. I was on the, even with everybody vaccinated and stuff, people can still get COVID with the Delta variant, and people can still suffer those. And the other thing is with the cold and flu season and all this stuff, when you have those other illnesses, you don't know whether it's COVID or what it is. So you have to be very careful. I had the great privilege of traveling over this last Thanksgiving weekend and being with my family in New Mexico, and getting the lights adjusted. It was great, but it's still nervous traveling in this time. It can be a little bit nervous. We went with my family. It ended up working out fine, and everybody had a great time. But it is still one of the realities of traveling during this time, right? So I wanted to ask some questions on our Ask a Lawyer show and answer some questions. So one of the first questions we had was that popped up on our stream here is, what are the differences, or what do I have to worry about in making a claim for an injury in Illinois? And one of the things that you have to be concerned about in Illinois is the time limit to make a claim. In Illinois, there is a 2-year time limit to make a claim or file a lawsuit for a personal injury for most claims. If it's a claim against a municipality, there is a 1-year time limit. So you got to be conscious of that 1-year time limit for sure. And that is a concern. So if you have a claim against a sovereign or a state for, let's say, a trash truck hits you, or let's say, I'm going to move my camera here. Pardon me. I'm moving my camera so that I can make sure that I don't get these lights in everybody's eyes and face all the time. So when you are in a injury in Illinois, 2-year time limit to file a lawsuit, but you start right away in making that claim, there's things you want to do right after you suffer an injury. You want to get the basic information. If it's a car wreck, you want to get who hit you, what is their information, take pictures of their license plate, their driver's license, takes pictures of the scene, at the accident scene, and the property damage, that kind of stuff. Then you want to make sure you get all your medical care right away. And you start that process right away. You don't wait the 2 years. If it's something like a injury you're at a store and there's a wet floor, they didn't shovel the ice or snow on time, you want to make sure that, hey Todd, how you doing? You want to make sure that you get the information to the owner of the premises and make sure that they know you slipped, know you fell, ask them to preserve the security camera tape, take a picture yourself of the location, keep the name of the manager who reported to you. If there's other witnesses to the incident, find that out. If there's other information about liability, meaning that you want to prove that the other side was negligent, whether it's a car crash case, whether it's a slip and fall case, medical malpractice case, work on the job, work injury, workers' compensation matter. You want to do your own work to prove liability at the beginning of the case. Don't just sit there and say, hey, I'm in a car wreck. I'm just going to write down some information and then I'm going to get a lawyer later and not do anything else. Well, you're the only one there who can take pictures of the scene, take pictures of the skid marks. You think, hey, man, this guy turned in front of me and ran into the side of my car. When I had a green light, they turned left. They failed to yield the right of way. There's going to be no question. Well, you would be amazed later when they talk to the police or talk to the justice, say, oh, I had a green light, or you were speeding, or whatever. So, or if you're slip and fall in a store and there's water, and then you're like, hey, there's water right here. The guy was mopping. There's no wet floor sign. There's no way they could contest that case. They're going to give it up and they're going to admit liability in the case. No, they won't. Don't assume they're going to do that, because that may not be true. They're not going to do that. So do your own investigation on liability. Take pictures of the skid marks, pictures of the property damage, pictures of the light cycle at an intersection wreck. If it's in a business owner, take a picture of the wet floor sign with no piso mojado sign, which means wet floor sign. They always say in Spanish piso mojado as well. Take a picture of that. Take a picture of the doors weren't closed right, or the ice on the ground at the apartment complex, or the fact that someone tried to shovel and salt, but they did not successfully do it, and they did a mediocre job, and that's going to be gone the next day or the day after that. By the time you get a lawyer, by the time they come out and do stuff, get your own stuff. People are great with that. The best investigative tool you have is your cell phone. If you would like a burger law doohickey, these are officially called doohickeys, that they have for the back of your phone, email me at Gary@burgerlaw.com. Email Kaylin at burgerlaw.com. We got these cool things. They keep all your stuff, and they have a little QR code where they have you can get on our website and get all the information you want about those cases. So do your own investigation in an accident scene. In a medical malpractice case, there's not as much investigation you can do, but what you do is you inquire with the manager of the nursing home, for instance, or the risk person at the hospital, or the doctor, and you say, listen, this is what happened to me. What's going on? I'd like some answers to why my mother was dropped in the nursing home. I'd like some answers about why you did surgery on me and you cut my nerve. I'd like some answers about why you didn't act on this test that I had 6 months ago that showed XYZ. Don't be afraid to ask questions and get answers. There may be good explanations about what happened to you, and then you're like, all right, I don't have a claim because the doctor gave me a good explanation about what the deal was. It may give you good information about a claim. I've had a variety of circumstances. met with one new client recently who said the nursing home came in and gave them a total explanation about what happened and said it's our fault. I have currently a medical malpractice case where even though they cut a nerve, they're denying that they did anything wrong. It's crazy. So you can't control. It's like the Serenity Prayer. You can't control how people are going to act or react. What you can control when you suffer an injury is your own conduct and what you do in the case. So do your own investigation, whether it's taking pictures at a scene, whether it's talking to a manager about a slip and fall, whether it's talking about a medical provider about possible medical negligence. Don't be afraid to do your own stuff. You're not going to mess it up. So there's a thought for you. So I have a question. All right, so I'm going to turn to some more questions. And let me turn to, and Mark and Todd Holder says, looking good, sir. Thank you, Todd. Appreciate it. Todd is a mustache guy. I'm sure he is jealous of my beard that I have right now, although every year I grow my beards, they come in grayer and grayer. So I think that speaks more to my age than anything else. I have a question from Mark Rulo that I'll put up here on the screen. Sorry if I'm looking down. I moved my camera up to here. Mick asks, Department of Corrections settlement, we got screwed, didn't we? No, you didn't get screwed. And no, there is no settlement. So what happened in the Missouri Department of Corrections case, Mick, is that the Missouri Supreme Court in a unanimous decision said that the Missouri Department of Corrections does not have immunity from the claim. There is a contract. It was breached by failing to pay for 2 out of the 7 pre-shift and post-shift activities that officers have to do. And the court said, hey, because this was decided on a summary judgment standard, go back to the court, have them look at the compensability of some of the other activities and recalculate the damages. Not a new trial, not a full-blown new this or that, but recalculate the damages. Tomorrow, I am producing our expert witness for a deposition by the state of Missouri. So what we did is we went back to the trial court. We have reset this case for trial in the second week of June in 2022. Mick, if you have information about this and you might want to be a witness, you can email me at gary@burgerlaw.com, or if anybody else does. Other people have been reaching out to me. We need witnesses. We're going to go back and we're going to put on the damages case again in June of 2022. Tomorrow, I'm producing my expert witness and economist about his amended or supplemental damage report in the case, which he did about a month ago. We got our expert to recalculate the damages per the Supreme Court instruction, update the damage numbers for a trial in June of 2022 instead of the last trial we did, which was August of 2018. And we're going to produce them for deposition tomorrow. And then we're going to let the defendants disclose whatever experts they want, proceed with the court scheduling order. We got a great new judge in Cole County, and we're going to proceed to a trial in the case and look forward to it. We intend to get a higher damage award than we did the last time because the class has suffered more damages since the last trial with the continuing conduct of the Missouri Department of Corrections. So you didn't get screwed, and there is no settlement, okay? I sometimes get questions from many of the amazing corrections officers in the state of Missouri. It's the biggest officer force in the state of Missouri. They always have around 4,000 to 5,000 people on the force, hardworking people doing very hard work. And I have a lot of friends in the Department of Corrections. I'm blessed to have COs and CO2s and other folks too. Some people go up to get elevated to different lieutenant or assistant warden or other capacities. Hard job. They still have to do this going in and out of the system of the institutions, various 21 correctional institutions in the state of Missouri without being paid for it, and we're going to keep fighting for them. But there is no settlement. There has never been any settlement. So, but if there is, everybody will know. But there has not been, nor has there ever been. I sometimes get questions about, hey, what's going on with the settlement? Blah blah blah. There is no settlement in that case. So let me move on to another question, if I could. I have a question from Todd, my diving friend. Todd asks, are there any definitive differences regarding injury liabilities in Missouri and Illinois and Missouri? Absolutely, Todd. Good question. This is shooting from the hip, but I'm going to give you my top 10 differences between Illinois and Missouri in liability laws. Number one, Illinois has a 2-year statute of limitations to file a lawsuit for injury claims. Missouri has a 5-year statute for general negligence, a 2-year statute for medical malpractice, and a 3-year statute for wrongful death. Difference number two, in Illinois, in a wrongful death claim, the jury instruction allows for damages for grief and bereavement and the sorrow for losing a loved one. Missouri law does not. The damage instructions in Missouri versus Illinois are different, and the damages awarded in both those states are different as well. Number three, Missouri has caps on non-economic damages in medical malpractice cases, which is always around $700,000. I think it's $740,000. So if you are paralyzed for the rest of your life, and you go and try, and the jury gives you $10 million for that, the judge will reduce that and for the non-economic damages portion only. You get your economic damage, you get wage loss damage, you get medical expenses past and the future, but the non-economic damages, meaning the pain and suffering, disability, disfigurement damages, those are capped in Missouri through tort reform. So those are three differences. Let me go to difference number four. In Illinois, both states have comparative fault, meaning if you're in a car wreck or slip and fall or something like that, both sides, the plaintiff can be assessed fault. If in Illinois, if the plaintiff is more than 50% at fault, they don't recover. In Missouri, it's pure comparative fault. So if the plaintiff is 95% fault, they still recover for those damages. Let me go to, am I there on 4 or 5? Let me go to number 5. In medical malpractice cases, Illinois has a statute that says that a lawyer has to cap his attorney's fee at 30%, and Missouri does not. So remember that if you're a plaintiff in Illinois, your lawyer should only be charging you 30%, a contingency fee. In Missouri, we charge higher, a little bit higher than that. Number 5 or 6, I lost count. So let's just say I'm 6 because I'm running out of ideas. In Missouri and Illinois, both of them have what I call lien reduction statutes. And what that means is that when you have medical bills in a case, and the medical bill providers make a sort of lien in the injury case to get paid out of that case. In Missouri, it's very strong law in Missouri. So in some ways, Illinois law is better in injury cases, and sometimes in Missouri they're better. But the lien reduction statute in Missouri, the medical providers are allowed to get a certain percentage of the recovery after attorney's fees and expenses. The plaintiff gets half the money, and the lien providers split the other half of the money on a pro rata or even basis. And then they can never sue or go after the plaintiff again. So it's a complete bar to any further recovery. In Illinois, that's not the case. In Illinois, you do have the lien reduction statute where the liens are reduced and whatnot, but the lien provider can still go sue the client later for the balance of the medical bill. So in Illinois, we always try to get full lien reductions and agreements with the provider, so our clients are not pursued that way. We take a very aggressive stance at reducing medical liens in cases, regardless of whether they're in Illinois or Missouri. 7, at trial, when you're putting in evidence of medical expenses in Illinois, you get the full value of the medical expenses, meaning that if the hospital charged $50,000 for medical expenses, the jury gets that $50,000 bill and that number. In Missouri, they don't. In Missouri, through some tort reform that was passed, in Missouri, the jury is only entitled to hear the number that was paid to satisfy that bill, meaning that if the person had health insurance and there was a $50,000 bill and the health insurance paid 20 grand of it and there's no remaining balance, the jury only hears $20,000. So the person only receives, so the plaintiff only receives, would likely only be awarded $20,000 in those damages. Here's my next difference in Illinois and Missouri. I'm either on 7 or 8 now. In a premises liability case, the law is a little bit different when it comes to snow and ice. So in Missouri, it's a new, if there's a dangerous condition on property, it's a knew or could have known standard, meaning did the landowner, the homeowner knew or could have known about this? It's a little broader. In Illinois, it's a knew or should have known standard. So should the person have known? And then, the other differences, and let me give you 2 more differences in Illinois and Missouri. In Missouri, when you're going and getting medical records and that kind of stuff, there's a statute where you can get an affidavit from the medical provider, and then that all comes into evidence, which is great. In Illinois, they don't have that. So in Illinois, a lot of times when we're gearing up for trial, if the other side wants to be jerks, they're going to say, oh, you can't get any of your medical records and bills, and you have to go take subpoenaed records depositions of the providers. So then we issue all these subpoenas, and then we have to go take these depots, and it's a little bit of a pain. It's our job. We don't mind doing it. We're not above it or anything. But then what typically happens in Illinois is the other side will stipulate to that, or we will do a request for admission. So, but I have had lawyers who have said, you got to go do this. And we go issue a bunch of subpoenas and we're getting ready for trial. And then when they see we're about to go take all these depositions, they stipulate and say, all right, we won't mess with you on that. And then, there's different rules in Illinois and Missouri about disclosure of experts. Illinois, the expert disclosure is more transparent. Missouri, you really don't have to say much. You tell them what the general nature of the opinion is of your expert, and then the other side has to go depose them. In Illinois, under 201K and some other rules, the expert disclosure is more robust and more transparent, which is actually better, frankly. The expert standard for whether or not in Illinois or Missouri a person can get on the stand and testify is different in both states too. Illinois is a little bit more liberal. Missouri had tort reform and established and adopted the Daubert standard for the submission of expert testimony as well. So those are 10 differences between Illinois and Missouri law. Sorry to pontificate or do it, but I'm shooting from the hip. And there's some other ones too, some other good ones. Let me look at the list of questions here I got. Let me go to some other questions. Thank you, Todd. Let me go to another one. Sorry, I'm looking down. Let me show Genevieve's question. Genevieve has a great question. Genevieve asks, sorry, I need to read it. What if someone is in a terrible accident in Missouri, has $150,000 in bills? Is this a test, Genevieve? And is there only $25,000 in coverage? What the insurance company offers right away without hiring a lawyer? Might it still be worthwhile to hire a lawyer? Could Burger Law negotiate? Hold on, Could Burger Law negotiate the liens and end up saving the client money? How does that work? Great question, Genevieve. And I swear I did not know that. I did not read that question when I was answering the question before about the difference in lien laws, medical lien laws in Illinois versus Missouri, which is what Genevieve's question gets to. I've had a number of cases where people come to me and say, I have 200 grand in bills, or in Genevieve's example, I have 150 grand in bills. There's only $25,000 in coverage. Yes, you can come to us because we have done this. This is more of a service to the client. Is under Missouri law, we can take the case. We get all of the providers to give us liens to get paid out in the case, or do we do file lawsuit, file a motion to adjudicate the liens, and then the lien holder is forced. The lien holders all together, and lien holders is the same word as bill collectors, is the same word as people who have asserted a lien in the case. They all have to split $8,333, which is a third of $25,000. Basically, the lawyers typically, we get a third. That's our typical contingency fee agreement. The client gets a third, and then the lien holders have to split a third. So you would, in Genevieve's example, you'd be taking $150,000 of bills. You'd pay them $8,000 to cover $150,000 bills. Good deal. And then they can never sue or go after the people again. One of the things that crushes people in America is medical debt. We have sad stories about people doing great, doing fine, or just getting by and stuff, and then they have a catastrophic medical incident and it wrecks them for the rest of their life, or drives them into bankruptcy, or ruins their credit, and it's super stressful. One of the good things that we can do for clients, and we are happy to do it, is use the Missouri lien reduction statute, which is a good and powerful tool to reduce those bills. So after the accident, the people don't have that medical debt following them around for the rest of their lives, or have to go into bankruptcy or something. And we do it, all the time. We're very aggressive on our liens. We have papers. I teach other lawyers how to reduce these liens. Genevieve is great at it too. Genevieve is a great lawyer with our office. And Illinois, it's a little bit different law. It doesn't write off those bills automatically, but whenever we are in Illinois, we, in many cases, a lot of our practice is we negotiate with the lien holders themselves and make sure that they sign agreements so that the client doesn't have that medical debt ever later. So if you do have a high amount of medical bills relating to an injury case, it is good to get a lawyer like someone at our firm, because we can help navigate those bills as well. When you walk away, when we're done with a case at Berger Law, we want you to be done. We don't want you to call us back 6 months later and say, hey, I got a bill in the mail. So one of the things we do is we call you up and say, listen, we're about to pay out this money, do this, that, and the other thing. Hey, have you have any other bills? You have any other things? Yeah, I've been getting this ambulance bill. I forgot to send it to you guys. And we're like, all right, cool, man, give it to us now, and we'll handle it. And we'll put it in the calculus, and we'll make sure they get paid, so you don't have any debt later go following you. Kara asked a question. If someone in Missouri is sued in small claims court and hires a lawyer, can they countersue for court costs? Yes. And in fact, they have to. So there's something in the law called a compulsory counterclaim, meaning that if someone sues you for breach of contract, you didn't pay this bill, blah, 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 you have an obligation. If you have a claim arising out of the same, it's called a common nuclear suboperative fact, but if out of the same deal, you have to do a thing. So if I'm paying someone to work in my yard and I don't pay them and they sue me, or I don't pay a credit card and they sue me, or someone sues me in small claims court, I didn't pay my vet bill, I didn't pay my whatever. If you have a counterclaim against them, like you didn't do the yard work, you never treated my dog, you overcharged, you charge a usurious or too high an interest rate, or your claim is just bullshit, whatever your defense is, right? Counterclaim against them. File saying you don't need to hire a lawyer most of the time in small claims cases. Most of the time it's not worth it. Why do you want to pay a lawyer a couple $1,000s to defend you on a couple $1,000 claim? So yes, you can handwrite, file an answer where you say, pay me this. And then on the court costs thing, file a counterclaim saying, pay me my court costs. Although I will tell you that Kara, if you're sued in small claims court, you're not going to have court costs. The person who files a claim in small claims court has a filing fee. It's usually $25, I think. and then has a service fee where they pay the sheriff to do that, which is usually $50 or under. It was less than $100. Small claims courts are good for resolving differences, disputes between people without getting in fights about it. So I'm a big believer in small claims court. It's really good. It can really help resolve disputes between people. All right. David asked a question about a new location. We're working on a new location, folks. I've been an Illinois lawyer for 29 years. I've been trying cases in different parts of Illinois, northern Illinois, southern, all kinds of places in Illinois, and we have a Belleville, Illinois office, and we've established a Chicago office. We hope to help people up in Chicago, northern Illinois, as well as continuing in central and southern Illinois, like we have. We have a good way of handling injury cases and helping people, and we want to take that show a little bit farther away from where we've been. My family's all from Chicago. My first job, I spent a lot of time litigating and trying cases in Chicago. It's a great people, great community, and I'm looking forward to do more work there. Brennan asked, sorry, I'm clicking through questions. I don't mean to not. Thank you, Todd, for thanking me. I don't mean to not look at the camera, which I will again in a second. Brennan asked a question about, not about bees for change. Brennan asks, what happens to damages if my child was hurt and have shared custody, split or whatever? Does one parent have more claim to damages than the other? What a great question, Brennan. Thank you very much. So if a child is hurt, the child has the claim. The parent does not have the claim. So what happens in those cases is the mother or father is appointed the mother and next friend. It's called a next friend. You don't have to really open a conservatorship or an official court document to official court case to a separate court case to have entitlement to do that. But if you're the parent of your child, you have a right to recover the damages for that child, even if you have a split home or co-parent with someone that you don't live with, whether or not you were married to them in the first instance or not. So the mother or father has that claim. Either one can make it. They should talk and cooperate with each other, knowing that the damages are not going to go to them. The parent can recover damages if they've paid for things like co-pays, physical therapy visits, braces, driving to doctor's visits, future expenses like that. Sometimes with catastrophic cases, sadly, those medical expenses can be significant. And we've helped people in those cases, of course. But in the run-of-the-mill case where your child is heaven forbid in a car wreck, heaven forbid bitten by a dog, heaven forbid slip and fall, heaven forbid medical malpractice, the claim resides, the child's claim, but if someone's under 18, they can't make a legal claim. So we file a lawsuit with the parent as the father and next friend, or the mother and next friend. The parent litigates the case and tries the case. Again, many cases are settled. If the case is settled for a minor in Missouri and Illinois, or in Illinois and Missouri, you have to go and get court approval, so that because the courts want to have oversight to make sure the cases are settled appropriately. It is not appropriate to settle a $1 million case for $1,000 for a kid. That would be inappropriate. So courts want to have that, and they conduct a hearing. I do these hearings all the time where you determine and assess whether or not the settlement is in the best interest of the minor. And then what you do is, if the parent has documented expenses, the mother or the father, then you pay those parents' expenses out of the settlement. And then the rest of the money is, you do something with the rest of the money to ensure that it is for the benefit of the child. So there's different ways to do that. Sometimes you put it in a restricted account. So it depends on the amount of the money and the age of the child. So if you have a 17-year-old who's about to turn 18 and you only have $1,000, you're not as worried about it. The courts usually aren't, and lawyers aren't. And I consider, so as I represent the child, I don't represent the parent, although I do represent the parent because it's the same thing in a way. But when I do this, number one is I make sure there's not a dispute between the parents of the child. If there is, we resolve that early on, and everybody has an understanding going into it who's going to get what and what's going to go. And I don't mind running that interference. It's sometimes in relationships there's tension or stress, so they don't talk to each other. So then I'm happy to bridge that gap. It's part of my job. But most people, when you get down to it, even if the parents don't get along, they both love their children and they want the best for the child. So that's what we address. And I've never encountered a parent that's not like that. I'm a parent myself. And I have kids with split homes, but it doesn't matter. Enough about me, right? So then you go to court and you get a court approval hearing for the settlement, and the court says what to do. So, but I gave you one example with a 17-year-old with $1,000 in damages. We just had that. By the time we got the case approved in Illinois, one of the kids had turned 18, another one was 17. So, but I also have kids where you have a very young child, 1, 2, 4 years old. I've had cases where you have a huge pot of money for the kid if the kid is significantly injured, if the child, which is again very sad. There's a couple of things we can do there. One is we put it into what's called a structured settlement or an annuity, where a AAA bonded investment company or insurance company sells you an annuity. You put the money to them, and then they say, hey, we're going to guarantee payments. When they turn 18, we're going to give them some money. We're going to give them some money for college. We're going to pay them X amount a month. We're going to buy their first house when they're 25 or 30. There's different ways to set up that structured settlement or annuity settlement with the parents, what the parents want. And I have a good company, trusted company, Atlas Settlements, Tom Parmalee, used for 20 years, who stewards this money for the child and does a fantastic job doing it. Another way you can do it, second way, is you can open a conservatorship. This is, again, assuming a young child with a big amount of money. And a conservatorship is a separate action, separate case, where it's a case, it's in probate court that's opened, where the money is put in different investment devices, and the court monitors that, watches the money. We file an annual report with the court every year to tell them what has been done with the money that year. We have several conservatorships that we help manage right now, and we always do. I usually encourage the structure annuity route for that, but sometimes people want a conservatorship, and that is fine as well. Another way you can do it is you can open an account with a bank. And it can be a restricted account where only X amount is allowed to be taken out a month, or you can say with the court order, only a certain amount can be, money can only be taken out for a court or by court order, or there's other restrictions, and there are certain banks that are comfortable with doing that. You can set up a trust. That is very rarely done. So those are the main ways you do that. And I know I moved a little bit past of what Brennan's question was, but I'm telling you, I get that question from folks all the time. David asks, why do most people, or many people, probably most people, I don't know, I haven't looked at that number lately, accept an insurance company's offer versus calling a lawyer to discuss the details of the case first? How much is the average difference between what they initially offer versus what you obtain for them? Well, let me ask the second question first. Is, I don't know why, but why not? If someone's already been talking to the insurance company, and many people do, I don't take the case unless with my fee, I can still add value to the case, including where I'll put more money in their pocket by hiring me. And so I always do that. I will never take a case where by hiring me, the client's going to lose money. I will only take a case where I can add value to the case, including my fee. The average difference, there is no average difference between what the insurance company really offers and what they obtain for them. But let me answer the question, that question a little bit differently. I have many cases, and we have them on our website and stuff, where we'll have a $250 offer, a $1,000 offer, and we get $100,000 or $250,000 for the client. We do it all the time. We just did it. for a client who they actually paid her $260. She took it. They sent her a release. She said, I'm not releasing my case. I'm just having you pay my first damn doctor bill. And they played a game with her. We fought it for a long time. We filed suit. They gave up. We got $50,000 in that settlement. And then we made an underinsured claim and got another large settlement for her. Great lady, good friend of the firm. We really fought long and hard for her and proud to do it. So I have a lot of great stories where it was only a little bit amount of money and then we got this big settlement. Now it is our legal work and our aggressive action towards and litigation experience and tactics against the insurance company. But it also is what's fair and what's right, because the insurance company is trying to take advantage of someone who's profoundly injured and hurt. And the reason why, going to David's first question, is the reason why people settle these cases out early is because they need the money. Okay. And when you're injured in a case, it's a profound life interrupted type of deal. You're going along, you're making this much money, you're doing fine in life, and then you have an injury where you can't work for a month and a half, and you have $50,000 in medical bills. Your cash flow is gone. You're hurting. You're scared. You're nervous. You're hurt. And someone offers you $10,000 where you can get by. And a lot of the people who take this money are worried about their kids and their family and not for them too. Like, oh, so I'm going to take the 10 grand, moms, I'm going to suck it up and not treat this back injury, but I'm going to make sure my kid has a great Christmas. And they're going to take the money every day. And that's what happens, because they love their family and they try to be safe and protect their family. And the concern about long-term damages or lifelong pain or that surgery they need 3 years from now. I want to have my kid have a Christmas and have that memory, or I need to pay rent, or I need to make this car payment. That's why people do it. And then the other reason why people accept an insurance company's offer versus calling a lawyer to discuss their case first is the insurance companies have a spiel or a tactic or a well-honed message. They train their adjusters to say the right things to get you to settle. They say things like, "It was a soft. The property damage wasn't that much in this crash. You can only get $2,000." That's not true. They say things like, "You only can recover for 6 weeks of chiropractic care. You can't recover for more." That's not true. It's not true, because you get 6 weeks of chiropractic care, but you have a herniated disc in your back. You need a surgery. Your damages are huge, or you're not healed from that. Or the chiropractic care, the soft tissue injuries, the bumps and the bruises are gone, but after 6 weeks, you're still hurting and you have a significant injury. Or there's only so much insurance in this case. Well, they didn't tell you that the defendant has an excess policy, so they only have 50 or 100 grand here, but they also have $1 million homeowners policy. Or they say that you were at fault at the accident, and you're like, "No, I wasn't. I'm driving along the road. This person pulled out and hit the side of my car. What are you talking about?" And they say, "Well, my driver says that you ran a red light." "I didn't run a red light. My driver says that your comparative fault," and blah, blah. Or the police got the report wrong. This happens all the time. Officers work hard and they do a great job and they do the best they can, but they're also out solving murders and catching bad guys. And your fender bender, they're doing their best, but they write their notes down. When they go put that later in their report, 3 days later, they've also reported 5 other accidents, because police officers work very hard. We represent a bunch of them always. And they do their best, but they get some stuff wrong, and that's okay. But what the insurance company is going to do is they're going to use that to try to take advantage of that incorrect information. I have taken many depositions of officers. Took one last week where they say, "Yeah, this is wrong. Not a big deal. I did my best, but I got the witnesses switched, or there was a witness, I forgot to put him in the report, or I got the cars switched, or the time of day was wrong, or yeah, I did a diagram on the police report. I was just trying to thumbnail it in. That's not to scale. That's not the purpose of this report, blah, blah, blah." So I say to people all the time, when you're at a car crash scene, do your own investigation right there and take pictures. The phone is the easiest thing. Pick up your phone, take a picture of the skid marks, take a picture of the other position of the cars, the cycle of the light, the failure of the right of way, and you'd be surprised at the scene. The driver who hit you is like, "Oh, it's my fault," blah 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 blah, and you think the case is going to settle. You have no reason to call a lawyer, and then boom, um, uh, they uh, they uh, they change their story. The insurance company, they want to CYA and do all kinds of other stuff. It's silly, but it invites litigation. So there's a lot. I have a book on the website about 10 questions to ask before you settle your case. Get that book up. We'll put a link to the book up in our. I'll put a link to the book while I'm talking, if I can. If someone else does it from our team doesn't do it before me, because I have a question about the 10 questions you ask before you settle your personal injury case. We wrote a book on this subject, and I'm probably in a race with David or somebody to do it. Let me see where my books are now. You know what, folks? I'm not going to find this right here for some reason. But if someone else could put Brennan or David or somebody else could put a link to that, that would be great. That would be wonderful. That would be helpful. We'll do that in the thing. And folks, look, if you have one of the other things about this question from David was, we answer questions for free at our firm. If you have a question about your case, call us up. Hey, I got injured. I got an ER visit. I did 2 chiro visits. They're offering me this amount of money. Should I take it? We have those questions all the time. And I'll tell you, yeah, take that, because let's give you an example. Like, you got $1,000 in bills. They offer you $5,000 to settle your case. You had 1 ER visit and 2 PT visits. Take that, because I can't get you much better than that. That's not a bad result. And you don't want to pay me a percentage of your recovery, because I'm not going to add value to the case. But if you call me and say, hey, I had those same things. I had an ER visit. I had a PT visit. And I had an MRI that shows a herniated disc in my neck. And I'm having numbness in my arm. And I can't hold a cup of coffee in my left hand. Then you need to call us, because you should not take that $5,000 settlement. You should figure out how much insurance that people has. You have a significant claim. You may need neck surgery, and you need to be compensated. And the back of my cup says the definition of compensation: to supply an equivalent, to offset an error, to make amends. So you need to be compensated, fully compensated for your injuries. And that low settlement from the insurance company ain't full compensation. If it is full compensation, take it. But if it ain't, don't take that. Come to a lawyer. We'll answer your questions. We'll figure out how much insurance there is. We'll figure out liability. We'll figure out and help navigate your medical care and make sure you get the care you need. We'll figure out the bills. We'll do all these things. So when you walk away at the end of the day, you feel that you know that the bills are paid, you have X amount in your pocket, feel comfortable and happy with the resolution of the claim. So that is to fully and more robustly answer that question. Thanks, David, for putting that link up. Thank you. We got 2 ones. We got both of them talk about the same thing, different things. Both of those are similar. Let me move on to another question. Maya asks, what actually is a lawsuit, and can I get money for my injuries without suing someone in Missouri or Illinois? So what a lawsuit is a document, a paper filed in court where you are suing or making a legal claim for damages against another person. A lawsuit can be a breach of contract case, can be a case about property, to divide property, to just say, hey, give me my property back. A lawsuit can be a lawsuit petition for divorce, to get divorced. A lawsuit can be a lawsuit for a class action case because a lot of people were damaged out of something. So a lawsuit can be a lot of different things, can make a claim for damages in a lot of things, but it's a civil, not criminal. And it is a way to join the battle in a claim that one person has against another person. When I say person, I mean an individual person, and I also mean a legal person like a corporation. Corporations sue people all the time, and they, and like credit card companies or a big company have a dispute with another big company. States can sue each other. There's a case in front of the U.S. Supreme Court now where Texas is suing New Mexico about water rights. There's a case being argued today in the United States Supreme Court about whether restrictions on abortion providers or sex education is appropriate because a state law did that. So those are what lawsuits are. And now a lawsuit in an injury case is the same thing. The person injured is suing the person who injured them, either an individual or a corporation or a combination of that. Sometimes a truck driver works for a trucking company, and so we sue the driver and the trucking company, or a doctor and a hospital, or a store employee and the store owner. So many times there's multiple parties' responsibility, or the store owner that hired another company to shovel their parking lot, they didn't do it, but they still have a non-delegable duty, meaning you can't get rid of that duty to have a safe place for their customers, but they messed up by not having that done. And also the snowplow company that they hired came in and did a bad job and didn't ice well or didn't do it, or there was melting and refreezing. So sometimes there are multiple individuals or persons to sue. Sometimes there are going to be a variety of things. So can you recover money without suing something? Yes, you can, all the time in Missouri and Illinois. So typically in a case, not always, we give the defendant a chance to settle the case before we file a lawsuit. We get our clients, we work with them, they hire us, we help navigate them through their medical care. And at some point during that care, they're going to reach their maximum medical improvement, meaning they're not going to get any better than where they are now. And so at that time, what we do is typically we get their damage records, their medical records and bills. We get their wage loss records, any other paper, pictures. We send a letter to the insurance company who represents the person who injured them, the tortfeasor, the negligent party, the rule breaker, the person who broke the safety rules and unnecessarily injured our client. And then we give them the information, their insurance company, the information that they need. Then their claims representative or claims handler then looks at it and decides whether or not to settle the case. Many times we settle cases without filing a lawsuit, and they say, hey, your person's really injured. We don't have a lot to dispute. We're not going to give you how much you asked for, but we'll give you less. And then we negotiate back and forth till we receive a resolution of the claim. And that's settling or resolving the claim. We probably settle 70% of our cases in our office without filing a lawsuit. Sometimes the insurance company won't pay that. Sometimes they won't do that. Sometimes they won't pay enough. Sometimes they're being jerks. So then in those cases, we file suit and litigate those cases. But even if you file a lawsuit, Maya, that doesn't mean that you can't settle the case. Even after you file a lawsuit, there are many, many times when the insurance company is delaying, not responding, not offering enough, or just plain tells us we don't believe in your case. We file a lawsuit, we litigate it, we take depositions, we do it, and then they say, okay, uncle, we'll pay you what you asked for, and we will compensate you for the true level of your damages and the full level of your damages, which is what we insist on for all of our clients. So just because you file a lawsuit doesn't mean settlement's off the table at all. In fact, with the Missouri Department of Corrections case, I started answering this at the beginning of the show, and I got about 5 minutes left. I'm going to be done with this show very quickly. Thank you, everybody, for listening and watching. So by the end of it, we're in all these cases, we're willing to talk settlement and resolve the case, but we just have not yet. So there you go. So, folks, Brennan has a question about how to split an apiary hive. So the way you split a beehive is you take, so that's the way that bees reproduce. It's not as exciting as some of the videos that Brennan watches, but the way bees reproduce is that the old queen will leave the hive and split the hive. And when bees are around and there's no queen after 24 hours, the queen stops giving off the pheromones or scents by which she governs her hive, then the bees will start to make a new queen. They will create a queen cell, and you can see this on my phone. This is a picture of a queen cell. I happen to have it. This is not a setup. I totally have this. That's called a queen cell. And so what they do, the bees do, is they take the eggs, they start feeding the number of the eggs royal jelly. So instead of the bee growing up that go through egg, larva, brood larva stages, and then bee over 26 days. In 16 days, they'll make a queen. They put them in these bigger cells. They feed jazzed up royal jelly to the eggs. They turn into queens instead of a regular bee. And then the first queen that hatches kills the other queens that were going to hatch. And then she's the new boss lady, and she runs the hive, and she's the queen of the hive. Everybody, that's that answer. That Ashley Thomas. Ashley has a question. I had an incident at work with another employee, and I feel like I may have PTSD. Could I sue? Ashley, email us at intake@burgerlaw.com or gary@burgerlaw.com. Let us answer that question. I don't want to hypothesize. That's a serious situation, and I don't want to. But I will get. But I'm going to answer your question, Ashley. But I don't want. But I think with a question like that, it's a little bit complicated. So I'd encourage you to ask us, and we'll answer your questions for free. We're not hard sell people. If you can call us for free, and we'll answer your question. And then if you want to hire us, you can. If we can help you, we can. If you don't, you don't. That's okay. We're not hard sell people. We don't have to be. Ashley, if you're injured at work, so here's the answer to your question. If you're injured at work, typically that is a workers' compensation claim. And whether you're in Missouri or Illinois, the courts often are going to limit your recovery to an injury there. And that's usually a physical injury where you're physically hurt. Now, there are separate laws, state and federal laws, that protect you from harassment, sexual harassment, harassment based on age, on race, other protected classes that have had historically discriminatory conduct. In those cases, you have a separate claim under those laws, and that's not work comp, against your employer and against the employee who's doing that. However, it's not illegal to be an asshole. So if the co-employee is just a jerk, or your boss is a jerk, and it's not sex-based or age-based or race-based, you may not have a claim. But also, I would also encourage you to report it, talk to your manager, try to resolve it, try to get that person away. If another employee is a jerk to you, if it's not an injury case, like they touched you or stuff, and you have a right not to be touched or harassed or struck at work. If it's just general, that person's a jerk, I guarantee you ain't the first person that this has happened to. If that person, so you may go and talk to your manager, and they may say, you know what, this has happened to 4 other people. This is bullshit. We need to do something with that employee. We need to get them out. We need to move them to a different section. We need to not have them relate to you, that kind of stuff. It's important. Stand up for yourself, Ashley. And you know what? You may want to leave. Sometimes I've done employment discrimination for years. I don't do as much now, but you remember sometimes you go look for another job, and then sometimes you can't change it at work, and so take the work. Sometimes we're hiring at Burger Law. I don't know. But look around. Life's too short not to be in an employment situation that you're happy and comfortable with, and no one should have to suffer those stresses and that emotional stress from going to work. It sucks to be driving to work, and it sucks to drive to work and be stressed out like, oh, great, now I got to deal with all these people. That is not a good atmosphere. Couple comments from David Jones. And David talks about working for a railroad or a barge company. David, I did FELA work. I've done Jones Act work. You're exactly right. There are, and airline sometimes. So there are certain jobs that, because there is a federal law that regulates them, it preempts or removes those from state law. And so if you're injured on the railroad, you have a Federal Employers Liability Act claim. I've handled those claims many times. If you're injured on a barge, you have a Jones Act claim or a Longshoremen's Act claim. And those have different benefits and different structures. Whether Jones Act is more and longshore, some of that times it can be more like comp. Sometimes on a boating case, it's removed from comp, and you have a right to a civil case in court, just like you do in a FELA. You're not governed by work comp, but you can go file suit in a regular civil claim you have with someone. If you have questions about that, I'm happy to navigate those for people, and I'm well versed in that area of the law as well. Folks, I've gone over. I appreciate all the questions. I appreciate the attendance to this. We're going to have another Ask a Lawyer show, our last for the year, on December 15th, 2 weeks from today. Tune in. I'll answer all your questions for free. But you get what you pay for. Just kidding. I'm not going to answer questions if I don't know the answer. I'm going to keep it real. Thanks, everybody. Thanks for listening.